Hello there. Now, you may have heard recently about the case of Liz, a young lady who brought a civil conviction case against her criminally convicted abuser from many years ago, and she won a large payout. And I'm talking today with Robin Tilbrook, a solicitor and leader of a political party, the English Democrats, and talking to him about his part in this case and how important it really is. And the first question I got for you, Robin, is how did you get involved in all of this?
Well, I've been thinking that this ought to happen, and that one of the grooming gang victims should bring a case against her convicted perpetrator. And I was talking with Alan Craig from Hearts of Oak about this, and we decided we would see if we could find a girl who'd got the courage to be the lead case on this. And we were lucky enough to find Liz, with the help of a social worker who helped her, Jane Senior. And we were then able to bring a case. And I think we've demonstrated with this case what actually can be done, because this is a case where the perpetrator has been convicted of two rapes against her when she was 13 or 14. And he was sentenced to 9.5 years. Of course, when it comes to actual time in prison, it's nothing like as headline grabbing as that, because of course he was actually only in prison for 4.5 years, 2 years of which I believe were in open prison, which is not really what most people would think of as prison at all. In fact, if anything, it's more like a sort of holiday cure.
Right. So, how long?
So we thought.
Sorry.
Yes.
When did this process start?
Well, do you mean the court process, or the process of thinking about doing this?
Yeah. When did it actually start? Right at the beginning. How long has this taken from conception?
Okay. Well, after we had the reports about what had been happening in Rotherham, I did try and advertise for a victim to come forward with the local paper, the Rotherham Advertiser. They refused to take the advert, and there was nothing in the advert really that would make them refuse, I don't think. I did do an article about that on my blog at the time, but the result was, of course, it was hard for me to as I'm based in Essex, it was hard for me to make contact with a victim, and it did require Alan Craig's good works to make this possible. But in terms of the idea of what to do, that's quite a long time ago.
Right. Okay. So it has taken a long time to come to fruition, but there were legal obstacles to overcome, I would assume, and also personal obstacles, which you've already hinted at. The courage required for someone to come forward like this, it takes a monumental amount of courage. So you've got two fights there. You've got to convince the victim and also then go through the legal hurdles. What sort of obstacles came up in all this?
So the legal hurdles are mostly bureaucratic, really, rather than difficult hurdles in themselves. I mean, obviously, the first thing to do really was to get a freezing order, an anonymity order, and once we've done that, we've then issued proceedings. That's all taken a lot longer than you might think it would, and partly because of the consequences of lockdown, where practically all civil servants are no longer working regularly from office, mostly from home. And I think the word working is a euphemism. Um, so everything takes much longer than you would think it would, or it should do, and it is, bureaucratically quite inefficient. However, none of that made any difference in the long run. It just meant that it dragged out for longer than it should have done, because the point is that as long as the situation is that the perpetrator has been convicted of a rape or whatever of the victim, then you can use that conviction as the basis for bringing a claim against them, and they are not allowed to argue in court that any of the facts that they were convicted upon were not true. So in effect, the trial on the merits is already done in the criminal courts. The only argument that could be raised technically is that there's been a long delay, and obviously in the case of Liz, she's now in her 30s, and it's quite a long time ago. But the man's been convicted, Mr. Ashgar Boston, and consequently, the law has been decided quite a long time ago now, that in these type of cases, as long as there's no prejudice to the possibility of a fair trial, then the case can go ahead, and that's basically what the legal position is. It's not even worth arguing from the defendant's point of view. It's going to go against them. So the only argument would be over how much the victim should be awarded, I think.
And in this case, it was £425,000.
Nearly £426,000. Yes.
Okay, they didn't round it up or down then.
No, it's a precise figure. I think the figure finishes in 9 pence.
Right. Okay. Yeah.
GB News did an item about this, and in that they do explain what happened, and there's a number of quotations from Liz.
Right. Okay. Yes. But did she came forward, and did she take much persuading, or was she already sort of mentally committed to this?
Well, the interesting thing is that none of the victims in Rotherham were aware you could do this.
Right.
And so the importance of the case really is not only as a sort of trailblazer or icebreaker, if you prefer, but it's also opened the eyes of quite a lot of the victims that they can now sue for this.
And that's really an important point. I mean, I think you told me before that you've actually lit up the target. So you've lit up.
Well, one of the analogies that people have used is it's like the Pathfinders in the bombing campaign in the Second World War. The Pathfinders went in, lit up the target, and then the bomber fleet came in and flattened the area.
Well, let's hope that continues in this one as well. Now, one of the things that does surprise me is that the press hasn't exactly leapt on this, in as much as it is groundbreaking, it is going to help a lot, or has the potential of helping a lot of people. So GB News has done a piece, but I haven't seen it much anywhere else, which disappoints me a bit. I don't know how you feel about it.
I would have been surprised if the press had shown much interest, bearing in mind that they were somewhat collusive in covering it all up in the first place.
That is a very
they'd hardly want to highlight the fact that they'd done that, would they?
No, that's very true. And is any of this sort of applicable or transferable to, shall I say, the public sector workers that might have turned these girls away? I mean, are they culpable for anything?
So many of the girls have sued the local authority, social services, and the South Yorkshire Police, in the case of the Rotherham cases. You've got to bear in mind that GB News actually did a very, very good documentary on this about 6 weeks ago, in which they were pointing out that the grooming gangs, so-called, have been operating in at least 50 English towns and cities. So this is a very widespread phenomenon. We're talking about, I think, at least 100,000 girls that have been raped and pimped. Also, I should think at least 10,000 perpetrators, if you count not only the gang members, but also their, as it were, paying customers or clients, because every one of those is guilty of rape, because these are underage girls. And in principle, sort of rule of thumb type figure, each rape of the underage girl is probably worth something like £50,000. That's the sort of ballpark type figure that the courts will come up with. GB News had a girl that was interviewed who had been raped over 1,000 times.
Yeah.
You imagine what kind of claim she's got.
Well, let's hope she can go through with it. Yeah, that would really open the floodgates, I think. And
it would. And in addition, of course, the gang members were in this not only for personal gratification, but also for money. Apparently, in many cases, they were making something like £250,000 a year off each girl by pimping them. And of course, that means that they are actually, the gang members in many cases are rich.
Yeah.
Back of this. These kind of cases could strip all that away from them.
Well,
that of course would be a punishment.
Yeah, best
that would be a punishment when you bear in mind that they're getting sort of 9 years or something like that for it, and only serving half of that, a lot of it in open prison. They're not really getting much of a punishment of the state, even in the exceptional ones where the state's actually done anything at all.
Yeah, because a lot of people would argue, well, they've paid their debt to society. Well, okay, that's what the criminal court does, but now they've got to pay their debt to their victims, and this is what this is about. And that's a really important point, I think.
I don't really think that 9 years for rapes on a underage girl is really paying the debt to society. I have a much sterner view of what criminal justice ought to involve than that.
No, I would agree. It is, but that is what the system is. And we'll come on to the possible causes for that in a minute. But what do you see going forward now? Are you hoping? Have you been approached by more people, or are you going out actively looking for them? What's happening now?
Yeah, so there are limitations on what a solicitor is allowed to do in terms of advertising. But of course, I can't really discuss new cases, but I can say that there are further cases that have come forward as a result of this. And I'm also hopeful that many other solicitors will be taking the view that actually this is not merely a strong case, but actually an almost certain type of case. If you've got a situation where you've got a victim who's got the personal oomph to want to do something about this, and one of the things about life is that not everybody has got any fight in them, but any that have, this is a fairly straightforward way of getting a decent measure of justice. It's nothing is going to fully repair what happened to them, but at least this could be a serious measure of justice for those victims. And secondly, where you've got the conviction, it's not possible for the perpetrator to argue it didn't happen. It would be quite a difficult case to bring if you were arguing in the absence of a conviction. So conviction's important.
Yeah.
And then there's the last question, which is also important, and that is that there are assets that can be enforced upon.
Right.
There's no point in suing somebody who hasn't got any money.
No,
You're just not going to get it coming out of it.
yeah, it cost you the money.
It costs you, yes.
Yeah. Now, one of the
But
things,
it is such a straightforward
right,
process that I would be hopeful that a lot of solicitors would do it on no win, no fee basis.
right, yes, that would make a lot of sense if it's as nearly as not exactly cast iron, but almost cast iron, as you allude to. Now,
Yeah.
one of the things that we touched on earlier was the repercussions for actually committing these offences. Now, you've talked about this in the past, and a lot of this seems to me to be about the judiciary selection process and how they have to meet certain criteria of diversity and all the rest of it before they can even be considered. What's your view on all of that?
Yeah, so what used to be the case up until Blair's prime ministership was that judges were appointed on the basis of what was known as sort of a tap on the shoulder. So barristers would appear in court, judges would be on the lookout for people who looked like they got potential to be a judge, and it would then be suggested to the then Lord Chancellor that this person was suitable. They would then be asked whether they wanted to be a judge, and they would then go through a selection process to check their suitability and check they haven't got any skeletons in the cupboard that would be a problem. And at the end of that process, they would be appointed as a judge. So fundamentally, the purpose of the process was to get the best courtroom lawyers to be appointed as judges. I think that system worked pretty well, but it had a disadvantage as far as Blair and his people were concerned, and that is it didn't mean that everybody who was appointed was a lefty, and it didn't mean that they all supported the Blair agenda, and you got a sort of cross section of opinions on the bench, and of course the other thing was that on a slightly different point, but I think we'll perhaps come back to it, many decisions were being made by juries. Now, following Blair's reforms, we've got a system where the Judicial Appointments Commission decides who's going to be appointed. The Lord Chancellor no longer has any central role really in that, and it's just rubber stamping decisions that have already been made. The Judicial Appointments Commission, like many of the quangos within the British state, is still filled with Blairite types, and of course the Conservatives, they've had plenty of time to change the people that are on that if they wanted to, or change the system indeed, but they don't want to, because of course they're just as multiculturalist as Labour. It's just that they lie about it. Whereas Labour, of course, are openly about this, and in fact, Lord Irvine, the last proper Lord Chancellor, he made a speech which ought to have got more attention than it really did, in which he said that this new system that they were putting in place would ensure that nobody with reactionary views could be appointed or promoted on the bench. In other words, it's an expressly political point about the way that the appointment system should work for judges. And of course, that system has now been in place now for 20 years or more. And consequently, you can be pretty sure that every judge that you're dealing with is going to be somebody who meets the way that the Judicial Appointments Commission has decided to implement that speech, which is that before they'll even consider an application, the applicant has to demonstrate a lifetime's commitment to equality and diversity. and that is something that they would all have to do. And if you take, for instance, one of the beneficiaries of that system, Lady Brenda Hale, the former president of the so-called Supreme Court. What's her qualification to be a judge? Well, let alone the apparently the most senior judge. Well, the answer to that is that she was a competent but not particularly distinguished academic lawyer, not a practicing barrister. But the thing that she got going for, as far as the Judicial Appointments Commission system is concerned, is that she was an active campaigning feminist. So, her qualification to become the president of the Supreme Court was that she was a social justice warrior.
Yes, and of course she is famous for the her Brexit intervention and the spider brooch and all of that. Yes. Remember it well. Remember it well. Yeah. So, and if this continues, it can't get any better, really. I mean, not selecting people with the best legal minds and the best practicing legal minds in court must lead to, I don't know, dodgy decisions or substandard decisions somehow, surely.
Well, we saw an example of what it leads to in the whole lockdown situation, because Simon Dolan, a multimillionaire who lives in Monaco, brought a case which went up to the Court of Appeal. And in the Court of Appeal, the current Lord Chief Justice, Lord Burnett, who has several times proved his credentials as a social justice warrior, of course, because he's been promoted several times. He was presiding on that case, and he did the lead judgment. And what happened was, of course, Simon Dolan was arguing for restriction or restraint on the state's powers to lock us all down. He was arguing on the basis of well-established legal principles, both relating to what lawyers call ultra vires, which is saying that a statute should only be used to create powers for ministers in a way that's relevant to that particular statute.
Yeah.
I'll come back to that point in a moment. And the other point was that it was breach of the human rights laws of association, freedom of movement, freedom of expression, etc. And family life. All of those points were very good points, and it seemed to Simon Dolan's lawyers, which I wasn't one, but it seemed to them that those points were so strong that they were pretty much unarguable that they were breaches. The judiciary, up to the point where the Court of Appeal heard it, refused even to hear the case. They just said it had no merit. They weren't going to even hear it. And that is part of the sort of appalling situation that we're now in with the courts and the judiciary. That if it's not the sort of case that they want to hear, they'd simply refuse to hear it altogether. Gets up to the Court of Appeal, and of course, what Lord Burnett's trying to do is to enable the state to win the case. And that's not surprising, because if you think about the meaning of equality and diversity, that if you look them up in the dictionary, they've got contrary meanings. So it's obviously not a description as such. What it is a jargon expression for a statist multiculturalist. And so consequently, if you're up before the courts as they are now, you are arguing really against the judge's deeply held pro-statist views. So if you turn up as Simon Dolan did with his lawyers, arguing again to limit the powers of the state, you've got your work cut out. And in fact, what happened was that the Lord Chief Justice chucked out pretty much the whole of the law of ultra vires. And let me explain that. So,
Yeah.
Although we had a lot of headline stuff when lockdown was first introduced about the Coronavirus Act, the actual act that the state and government decided to use wasn't the Coronavirus Act. That was just used to change all sorts of rules of law that were nothing to do with the coronavirus, that happened to be sort of trendy, like the British Secretary of State for Health didn't like Northern Ireland not having an abortion law. So they changed that without having to go through Parliament properly. But what they actually used to lock us all down was the 1984, appropriately enough, Act, which was the Public Health Control of Diseases Act, 1984. Well, that was an act that was about restricting polluted or diseased goods or individuals coming off ships, basically. It was really a control around the docks type of legislation. And it didn't give ministers powers to do anything. It gave magistrates powers to confine people who are ill or goods that were infected. It didn't give widespread powers to lock down the whole population. It didn't give powers to lock down people who weren't ill. It only gave, as I say, magistrates powers to prevent the disease getting out of hand, coming off the docks. So you're quarantining people who are infected. That legislation was then used to lock down the whole country, England. With even people who were not ill, well, mostly people who are not ill, of course.
Yeah.
And you would have thought on that basis, it would be ultra vires to do that. It would be outside the powers of ministers. So for the court to suddenly say that actually it doesn't matter, that it was outside the powers, because there's some sort of an emergency, demonstrates that they have actually just chucked out most of the basic law of how ministers' powers should be controlled. And it is worth, I think, comparing that with what happened in 1933 in Germany, when after the burning of the Reichstag, emergency enabling act was introduced and passed by Parliament, and that then enabled almost everything that the Nazi regime thereafter did to be legal, and the judges upheld that it was legal when all sorts of citizens' rights were removed by order of ministers.
Yes, it is rather strange that at the time they were very keen on shutting down, as you point out, our human rights, but at the same time right now they're making sure that human rights are now being used almost against us to allow other people to roam free, as it were, around the country. It all seems very, very unusual and very strange indeed.
Yes, I mean the human rights arguments are being used very selectively, but then this is part of the struggle between left and right, as it were.
Yeah.
The internationalist, statist, multiculturalists as against more patriotic, traditionalist people, and one of the there's politics fully, aren't we here? One of the issues really is that the system of the pendulum swinging backwards and forwards has been completely broken by the fact that there is no establishment big party that is actually patriotic or traditionalist. Most conservatives, so-called, wanted to remain in the EU. They were really more or less Lib Dems in disguise. I mean, think Heidi Alexander or Anna Soubry.
Yeah.
They weren't really conservatives in any meaningful sense. They were using the system to game it in order to advance their multiculturalist, internationalist, Europhile agendas. Obviously, lots of ordinary people were, and I think in many cases are, still bamboozled by the labels, and they can't quite understand why it is that the Conservatives are just not doing anything that's very conservative. But then I think they ought to be reminded of David Cameron's famous or infamous saying, which was that he didn't support gay marriage despite being a conservative. He supported gay marriage because he was a conservative.
Yeah. Very strange view some of these conservatives do have, especially when you consider they are conservative and unionist, and what they've done to Northern Ireland is just another example of how far they've strayed from their allotted path, or their advertised path, against the Trade Descriptions Act almost. Yes.
Well, mind you, under the Trade Descriptions Act, pretty much all the parties ought to be in Parliament ought to be done, shouldn't they? Because I mean, you couldn't say that the Liberal Democrats are either liberal or democratic. Labour is not at all about labouring people. It's entirely about multiculturalist internationalists, and then Greens are the Watermelon Party, of course.
Ref captured, I think, is the yeah. Now, we're sort of running out of time now, but just to get back on point, it's back to the case of Liz, which was a really, really good result. And I had a quick chat with one of the guys from Hearts of Oak, just congratulating them on their part of doing this. Just want to congratulate you on your part of doing this. Because at the end of the day, if we're going to stop this sort of behavior, we've got to go after these individuals and hurt them and hit them where it really hurts, in the pocket. And that will send out a very, very stark message.
Well, that's certainly what I hope will be the case. And it's one of the reasons why I wanted to bring this case, to make it clear what could be done, and to also incentivize those people who could bring cases to do so.
Yeah.
Because I think the fact that it is, for two rapes, that we could get a ruling for over £425,000. I think that does show what could be done, and certainly where there are many more rapes than that, or convictions for pimping, then the awards could be very much more than that.
Yeah, and that final point, trafficking these girls was so lucrative. That should make people sit up and really take notice of what's going on around them, wherever they live.
Yes, well, and I think the other point is that the fact that they were able to, I think I prefer the word pimping than trafficking, but I suppose it's
yeah,
you're using more official language there. The point is that they were only able to do this because there was a significant number of men in the community in question. Am I allowed to mention that? Who must have supported it, yeah. And not only supported it, but they were prepared to pay.
Yeah, it's very, very sad. Well, it's really great to hear from you, and really great to hear of this success. And let's hope it continues, and keep us updated in the future. Please do. And so, ladies and gentlemen, there you have Robin Tilbrook, solicitor and leader of the English Democrats.